And hello and welcome to Women's Declaration International webinar. We're missing our usual host tonight, Janet Fraser, but she has organised some wonderful speakers for us, and we're going to move to them very quickly indeed. I mean, it's been a great month. There's a lot of things to cover, especially there's been certain phenomenal cases, and I think our first speaker is going to talk about that. So I won't talk about it. So Joe Bartosch, I'll introduce each of the speakers as they come on, and we'll start with Joe Bartosch, who really doesn't need any introduction. I'm sure, like me, most of you have seen her name and read a lot of her work. She's assistant editor at the Critic. She's widely published as a journalist and co-author of the upcoming book Pornocracy, which we look forward to as well. And so with that, I'll pass over to her.
So thank you so much for having me. So I was just going to do a bit of a straightforward overview of the Supreme Court ruling in the Four Women and Scottish Ministers case. And I'll touch a little bit on the reaction that's followed as well, which has been insane. So on the 16th of April, the UK Supreme Court clarified the law, and it ruled that the word sex in the Equality Act refers to biological sex, and that obtaining a gender recognition certificate doesn't change that. The wording is absolutely crystal clear. A biological interpretation is necessary for the provisions of the Equality Act to work, and that's, the point of the law. So, and it's very clear that as well, a biological interpretation was found to be necessary for the provisions of the Equality Act to remain coherent. So the response to the 88-page judgment, which was the work of 5 of the most respected British legal brains, has, as I say, just been absolutely insane. There have been trans rights protests across the country. News outlets have been desperately canvassing the opinion of cross-dressing men. There have been sort of claims that it's a descent into Nazism and fascism. It's all been absolutely insane. So the ruling, if I give a bit of background to how the ruling started, it was followed a legal challenge by Four Women Scotland to the Scottish government because they defined woman in the 2018 Gender Representation on Public Boards Scotland Act to include men with a gender recognition certificate. And they're actually, they make a lot of fuss about how hard they are to get, but they're not. Essentially, you pay £5, you get an online diagnosis of gender dysphoria, and it gets signed off. So, in 2018, the Scottish Parliament passed that law with the stated aim of improving the balance of men and women who sit on the boards of public companies. But the Scottish Government have long been lobbied by trans activist groups. They fund the very groups that they're lobbied by. So obviously, they defined woman to include any man with a gender recognition certificate. So Four Women Scotland, they described this as a Trojan horse. And I think it is fair to say that the Scottish government knew exactly what they were doing because this was part of a wider pattern. So at the time, they were really pushing to erase sex-based protections, and the former First Minister Nicola Sturgeon, as the case was ongoing, she tried to introduce gender self-identification, as did the person who followed her. Thankfully, that was blocked by Westminster because it's a devolved government in Scotland, so they don't have quite the same powers as the Westminster government. So it was deemed that would have impacted on the whole of the UK, so they had to roll back on that. So that's the sort of backdrop to what was going on as the court was sort of presiding over this. And as I say, they lost the first case. So they won the first case, lost the second one, and then finally won it. So more widely, obviously this is so they won they won the first case, and that was appealed by the Scottish government. Then they lost the second, and the ruling for that came from 4 judges, all of whom backed the Scottish government's position. And I think that really shows how detached the lower courts have become. And there was a really confused ruling from Lady Haldane. So she's a judge in the Court of Session. This is the case that they lost. And she decided that biological sex was, for the purposes of the Equality Act, changed once a gender recognition certificate had been issued. So she dismissed the concerns of lesbian gay lobby groups, and she suggested that their reasoning of what a gay man and a lesbian was hard to follow, and she claimed that there was no such thing as being legally lesbian. So under that logic, obviously, people would be expected to be sexually orientated to not sex, but those in possession of a gender recognition certificate. And they made quite a lot of that when their case was challenged. So, yeah, the Supreme Court ruling on the 16th just absolutely demolished her analysis, or the analysis of the four lower judges. So they considered evidence from four women in Scotland, obviously, who brought the case, Sex Matters, and then a coalition of groups representing lesbians who were known as the lesbian interveners. And they really sort of made mincemeat of the Scottish government's case. So basically it reaffirmed, I think crucially, and this is really important, the definition of lesbian. So, woohoo. Then Amnesty International intervened on behalf of the Scottish government, which is unsurprising given the turn they've taken over recent years, as did the UK Equalities Watchdog, the Equality and Human Rights Commission, so the EHRC. So some people were quite surprised that the EHRC decided to intervene on behalf of the Scottish government. And it was rejected, but what they said was that the matter ought to go back to Parliament and that it ought to be decided by Parliament. And yeah, thankfully that failed. So the Supreme Court basically found that the Gender Recognition Act remains in effect, but it doesn't override the Equality Act in contexts where doing so would create a legal contradiction, so it would create legal incoherence or contradict the purpose of the Act. So, and that was sort of at the heart of the case, whether the GRA modifies the Equality Act. So it was unanimous, and it was very clear that neither paperwork issued by the state, nor vibes, or the feelings of men, or whatever the hell else altered biological sex. I'm sorry. I hope I'm articulating myself properly. Anyway, so as of the date of the ruling, any organisation that retains a policy that doesn't recognise single-sex spaces, that says that as only being for people of one sex, is potentially authorising unlawful discrimination against its female staff. And the ruling explains that the provisions in the Equality Act allow men to be excluded from women-only spaces and services, and that's because it's considered to be a legitimate aim to protect the privacy, dignity, and safety of women. It also made a point of highlighting that the Equality Act is a consolidating statute. So it brought together, when it was passed 15 years ago now, it brought together the Sex Discrimination Act, the Race Relations Act, and the Disability Act, Discrimination Act, and the Gender Recognition Act. So basically, to avoid falling foul of the law and inviting legal risk, all public and private organisations must now review their policies, their guidance or HR practices that conflate sex with gender identity. And they keep saying biological sex in the court ruling, which is annoying, but I understand why they did. So, notably, people who pretend to be the opposite sex remain protected under the Equality Act because gender reassignment is a protected characteristic. But they also retain protections based on their sex. So the judges were really sort of clear about that. What it means is the rights recognise that for people undergoing so-called gender reassignment or any part of that process, so they didn't create a new legal category of trans men and trans women. They just said essentially if so. The implication being, a woman who identifies as a man, because her sex is now recognised in law, she's protected by maternity discrimination legislation. So actually, it means that so-called trans people have more rights in law, and it's because it recognises their sex. Also, it does make some provision for where it would cause, like, alarm or distress, because obviously testosterone is a very powerful drug. I think its effects are much more pronounced than a man taking estrogen. So where a woman is quite a long way down with her sort of medical transition, whatever, wanting to appear as the opposite sex, where she actually looks like a man, and where she thinks she might cause distress to other women in a women-only service, she can self-exclude. So again, there's been this gotcha doing the rounds on social media and all the rest of it, which is, well, men can say they're trans men and walk into women's loos. How are you going to tell? Well, to be honest, anyone who looks that much like a man has got the option to go into either a unisex loo or whatever else is available. So anyway, so since the ruling, the EHRC commissioner, Pure Reindorf, so she's been very clear, even though the EHRC did intervene on behalf of the Scottish Government, but she's been very clear, and she told the Times, unless the legislation is changed, the judgment is the final word on the defining question of the debate: what is a woman? The answer, at least in discrimination law, is that a woman is a person who was born female. I mean, there's a bit of me that just thinks it's mad that it's taken 5 judges, however long, to tell us what every toddler and every dog knows, but still, it's there. As the judges stress themselves, statutes should be understandable, they should be constant, they should be predictable, and they should use the ordinary meaning of words. So that means the ordinary understanding of sex is what took precedence. So the Supreme Court's ruling interpretation is binding, and it supersedes any contradictory guidance. Yet, despite the ruling being very clear, many organisations, including the Law Commission, Rape Crisis England and Wales, and even the London Marathon, are now saying they need to wait for EHRC guidance. Now, the EHRC themselves issued a statement saying that they're working on guidance. In the meantime, organisations ought to just interpret the law as it is written and just to get on with it and to stop sort of, waiting for them. Then yesterday, they did release some interim guidance, which essentially says everything that the ruling says. It says, it's very clear. It just says men are men, get over it. So the response, as I say, has been insane. You've had politicians who have really split the Labour Party, which previously was sort of very heavily pushing for gender self-identification, as were the Tories for a while. So the Labour politician who actually drafted the Equality Act, Harriet Harman, who's now a peer, she claimed that it was always what ministers had intended when they were drawing up the legislation, which is interesting, seeing as she didn't say a bloody word when people were being forced out of their workplaces, their social groups, their organisations. She kept totally stum, and now she's apparently saying that it's a matter of that she'd always agreed with it anyway, blah, blah, blah. So obviously we got Keir Starmer, our Prime Minister, who pushed Rosie Duffield out of the Labour Party for saying that sex is real and that it matters. And he once said that trans women are women. His office have rolled back on that. He hasn't said it directly himself. He's sort of deferred it to his office, and has said that he supports the ruling, but he hasn't apologised to Duffield or to any of the women who were slandered for years. And there have been some really powerful statements made in Parliament about the work of feminists, actually, which has been heartening. The Liberal Democrats have issued a statement saying that the ruling has caused confusion and worry. So that was Lisa Jardine as their equality spokesperson. But whether it causes confusion or worry or not, they're still going to have to enforce it. I mean, and the Tories have obviously been having quite a lot of fun using it to bash the current administration. So there is talk of a legal challenge. So the Good Law Project which is basically jolly and warm. He's the barrister who infamously bashed that fox to death whilst wearing his wife's kimono. And he's a tax barrister, so I don't really know why he's got any involvement. Well, I do, but he's trying to do a fundraiser to challenge the ruling. There's been guidance drawn up, I think, by a male barrister who calls himself Robin Moira White, which is like a little card which you hand to people to say, you know, you're infringing my rights as under the European Convention on Human Rights. You're infringing my rights to use this toilet. If any women are, you know, so have the temerity to challenge him in a loo. Yeah, so the reaction has been insane. But I think finally, the sort of fretting of institutions and their political equivocation and all the rest of it have just been blown out the water by this absolutely clear and unequivocal ruling. So let's just hope all other countries are watching and that it sparks a wider kind of pushback against this abject nonsense which has reduced women to a feeling in porn-addled men's heads. I hope that's clear.
No, it was brilliant. It was a really good presentation. Thank you very much for that explanation.
No, you're welcome. You're welcome.
It's
Has
been,
anyone got any questions that I can answer maybe whilst you're sorting out the technical
now
stuff?
that brings me back to something I was meant to say at the beginning. But look, if people could put your questions in the Q&A, and then we'll ask those at the end of the formal part of the presentation. But what we'll do at the moment is we'll go to the next speaker. She peaked about 3 years ago and immersed herself in the work of women and men critical of gender identity ideology. She joined WRNA and is now a member of their organising committee. I cannot believe that women in 2025 are back to fighting for their basic rights. She also can't believe that the people who see her as the enemy include young and older women who have uncritically embraced this harmful ideology. Thanks very much. Over to you.
So thank you for the invitation to speak tonight to Women's Declaration International Australia and New Zealand. I'm going to talk about who WRNA is, the Women's Rights Network Australia, an overview of our 2023-24 activities, how we've recently become incorporated, formed an organising committee, and I'll talk a little bit about our recent activities and what we hope to do in the future. So our primary objective is really simple. It's to defend the sex-based rights of women. We've just left it as simple as that. Our goals are to retain the hard-won rights of women and girls, including our right to single-sex spaces such as prisons, hospital wards, healthcare, changing rooms and toilets, to repeal policy and legislation that prioritise gender identity over sex. So, Jo, currently in Australia, under our Sex Discrimination Act, the definition of man and woman was removed in 2013, and gender identity became a protected attribute. And we currently have a couple of court cases on at the moment where gender identity is being given priority over sex. We're also committed to stopping the medicalisation and indoctrination of children, young adults, and vulnerable people who are encouraged to believe that it's possible to change sex. And two more, to reinstate the words sex, mother, and woman, women into common language and law. And also, of course, to support and work with other women's groups, efforts and campaigns across Australia and actually internationally to work together to defend the sex-based rights of women. So those are our 5 major goals. And how we operate is we're a non-partisan network of women across Australia. So we have women from all different political persuasions, which makes it interesting but fun. We're a volunteer, member-led organisation. We're exclusively for women and we welcome women regardless of sexual orientation, race, religious beliefs or none, disability, employment status, parental status, economic background, etc. And our focus is connecting women and not on building a hierarchy. So, our history. So, the group was formed by Jess Williams and Kit Kowalski in March, April 2023. They had met or started talking to Heather Binning, who founded the Women's Rights Network in the UK. And we've modelled our organisation on that group, and we consider ourselves to be a sister organisation. While WRN UK has about 3,000 members, we currently have 100 members, but we're hoping to build on that. And we do a lot of submissions, and built a website and developed online connections, started social media campaigns. Something we did, I want to talk about state-based. So we have women from across Australia in different states, particularly New South Wales, Victoria, South Australia and Northern Territory. It'd be great to get some women from Queensland and Western Australia too. And ACT, Canberra. So part of the history, so state-based initiatives and campaigns involved lobbying MPs with letters. There was extensive leafleting for the Fair Women's Sports campaign at the World Cup. South Australian members asked Julia Gillard, Jo, who was our first female Prime Minister, under whose leadership the Sex Discrimination Act was changed. So South Australian members asked Julia Gillard, what is a woman? And apparently that went viral. So that was a fantastic opportunity to question the person responsible for overseeing those terrible changes to our Sex Discrimination Act. Members contributed funds for billboards in Victoria and New South Wales for sports and sex self-ID campaigns. And then there was an 18-month-long campaign called This Is Not Equality. It was an intensive lobbying and collaboration with the LGB Alliance in Australia, Australian Feminists for Women's Rights, and the Coalition of Active Lesbians. A lot of work went on. And I've just got a few photos here. That's the billboard that we funded. And here's some leafleting and going on by members. So early 2024, we actually started to see a lot of membership burnout. And our general and specific public-facing activities started to slow down. Our co-founder, Kit Kowalski, had resigned, and there was a period where we had a leadership gap. We had no direct leadership. However, women continued to talk to each other and network, share information. There were state-based social get-togethers and some smaller lobbying and campaign activities. So then late last year, there was a call out to WRNA women to form an organising committee and sort of get things going again. And we formed it in, sort of late November. And we've been meeting every week since then for about an hour or 2 hours every Monday night. We see ourselves as being responsible for steering the strategic direction of the organisation and doing all the administrative stuff. We've got 9 women on that committee. all of whom are working really hard to get things going again. Now, so what have we done? The organisation was incorporated in December 2023 before the hiatus. So we have to, as an organising committee, we have to finish the incorporation processes. We're incorporated in New South Wales, but we have a national scope and remit. And we're currently working towards our first annual general meeting in, I think, July. And we'll do a proper election of organising committee roles according to, the model rules for Constitution. So we're going through the Constitution to make sure it's fit for us. So we've used a sort of pro forma Constitution, and we're adapting that. We're finalising our operating documents, procedures and policies. We've got to tell everybody in the organisation, 100 members or so, that, we've become incorporated and now we need to have an AGM, collect fees, and we've been doing a lot of work on reviewing and updating our membership policies and processes. While we were on hiatus, it looks like, going through our sort of back-end tech, that, more than 50 women had contacted Women's Rights Network Australia wanting to join. So we're in the process now of contacting all those women and apologising for not getting back to them sooner. And we've got to go through a vetting process. Each person has to be interviewed face-to-face or on video calls. And then the membership team that we have will make a recommendation to the OC to include a new person, and then there's a whole process for onboarding them. So it's quite elaborate, and the fact that Kit did 100 of those on her own is pretty amazing. So we're also reviewing and updating IT systems, our website. We're reinvigorating our social media presence. Heather Binning from the UK came down a couple of months ago, and so we had a couple of opportunities to meet with her and talk about our progress and also hear about what's happening for their group. And of course, we've been campaigning around the federal election. So we managed to do a mass mail out to 700 sitting and prospective federal election candidates, with some help from an IT person at LGBT Alliance. So we developed a letter, and it went to all the major parties, all the candidates within the major parties. Do we expect them to respond? Not really. Do we want to highlight the issues that are going on for women's rights? We're particularly concerned about getting through to those politicians who might actually not have any idea that in Australia right now, men who claim to be women legally have the right to enter into women's toilets, changing rooms, prisons, domestic violence centres, refuges. We think some people actually don't know that. They don't realise the stark reality. So we're sure some, say members of the Green are going to tear up our letters or not respond or hate our campaign, but we're hoping to get through to people who may not have put much thought into defending sex-based rights. Okay, so upcoming activities. So we're going to start hoping, to contact all the women who have contacted WRNA over the last 6 months. We're planning on a strategic planning meeting after the federal election and our first AGM. We'll do more campaigning, lobbying and submission. And basically, we just want to get louder and more well-known. So thank you for listening to an overview of what Women's Rights Network Australia is all about. I hope you found it interesting. We welcome contact from interested women who might want to join. The more the merrier. And that is it from me.
Wonderful. Thank you. It's so good to hear that we've got more active women's groups now. I think there's now about 4 that I'm aware of who have made contact with the candidates for the election, and it's really good to see that the organising is happening. And of course, we all understand about the burnout because none of us, I don't believe, have any funding, and it's all volunteer effort that women are accommodating. So it's really good to hear about the efforts of WRNA, and there will no doubt be questions to come, but let's move now to our next speakers. Now we've got Janet who is our New Zealand country contact for Women's Declaration International, and she's going to interview Suzanne Levy. And Suzanne Levy is a lesbian and a mum from Wellington. She is the spokeswoman for Speak Up for Women and is focusing on areas of legislation and policy where sex-based rights have been misrepresented by hugely successful but wrong activists. She enjoys tennis, golf and karate and hanging out with her family. In her other life, she is an IT consultant. Over to you, Janet, for that.
Oh, hi there. Yeah, so Suzanne is the spokesperson and co-leader of Speak Up for Women New Zealand. There's been a lot happening as we've been talking about in the UK and in New Zealand over the last week or two. And we've just heard Joe talking about how in the Supreme Court the word for sex is now definitely defined as biological sex, and woman is biological woman. And it doesn't matter if you got a gender recognition certificate, that doesn't mean you are legally the opposite sex. So could you tell me, Suzanne, what is the response of Speak Up to Women to this? And how have you seen the response happening in New Zealand? And what do you think the implications are for New Zealand?
Okay, so the response has been, our response is that it's a fantastic decision. But there are, key things that we got out of it. The first thing that we love about it is the term certificated sex. I think it's a phrase that we've all been looking for a while, and it's, we all know what it means, and you kind of know it when you hear it, and it's that kind of thing. And the other thing was the way the judges described the coherency of the act, and I think that's where the Equalities Act and the Human Rights Act are really similar in that if sex doesn't mean biological sex, then a whole range of sections in the Act are just not coherent. They're just nonsense. And so I think some of the wording from the judgment is just sensational. It's like it's such good material to use. It's actually not it's not written in a way that makes it inaccessible or ridiculous to read and to quote. And so I think that my favourite one is the one in terms of lesbians not being attracted to what is it? I'm sure you know it, Joe.
Certificates,
yeah, not being attracted to it. Yeah, not sexually oriented towards a person in the possession of a certificate. That's just it's musical, isn't it? Yeah. So I think there are lots of similarities in New Zealand and the UK, as I said, and we're working through how we can leverage it to the maximum. So and the funny thing here is that we've got trans rights activists who are saying, nothing to see here, it's nothing to do with it's UK law, it's nothing to do with New Zealand, but at the same time they're having little hysterical moments all over the place about how terrible it is. So so have I answered any of your questions yet, Janet?
Yes, you have been talking about some of the response in New Zealand and what your response is at Speak Up for Women. That's fantastic. So the other thing was about the implications for New Zealand, but we can also go through some other questions and we'll draw them out there if you want. Well, you can talk.
I was going to say the interesting thing about New Zealand's situation is that we had sex self-ID pass in 2021, but it has a section in the legislation, and the section is called certificates as evidence, and it basically says that a birth certificate isn't necessarily evidence of somebody's sex. So while the birth, deaths and marriages legislation, the sex self-ID legislation, makes all sorts of changes to what you can do to a birth certificate, not just sex self-ID, but various other things as well. It also says, look, this certificate doesn't really count in terms of sex, and it came through during the legislative process that there was only one organisation in New Zealand, or one government organisation, that used the birth certificate sex marker in any meaningful way, or any way at all, and that was our prisons. So in New Zealand, it's called the Department of Corrections, and they had a policy that said you had to put an inmate in the prison that matched their birth certificate. And they were the only one. It was really interesting. Even schools, when you apply to school, they need your birth certificate, and not as evidence of your sex, just evidence that you're allowed to attend school in New Zealand, that you were either born here or whatever. So, yes, corrections was the only one. And as part of passing the self-ID law, one of the provisions was that was changed, and that corrections could no longer say we will only, that we have to follow the birth certificate. So we've got the section, it's called Section 79, which is the lovely little out clause, and we've got the fact that corrections were able to, or that they had to change their law in order for this to be passed. It was a condition. It really says we don't believe that you're changing sex, or that your birth certificate has changed your sex. And that's where that lovely phrase certificated sex comes in, because that is what we have. And clearly there's biological sex and there's certificated sex. So this is a really good way of kind of highlighting how that's working for us, and it's giving us a chance to articulate that, because it's a really complicated issue to get across to people. And that we have self-ID, but we don't have self-ID. So this is actually helping. It's helping us to do that.
Yeah. There's a parallel there between what the Supreme Court has just said about this gender recognition certificate and what and how it's not really about what sex someone is, and there's a bit of a parallel with our law, which says, well, the birth certificate isn't really necessarily verifying your sex either, sort of thing. Yeah. So
yeah, exactly. Yeah.
That's cool. How about the Law Commission, as you know, are looking at, have made proposals to change the Human Rights Act, and are developing this right now, and they are proposing to add gender identity and expression into the Human Rights Act. How do you think that this decision of the Supreme Court would influence them, or would it?
Firstly, I don't think that they haven't proposed that. They haven't made any recommendations at this stage. So they are going to be putting a paper out. That they said it would be the middle of the year. So I'd be thinking in a month or two. And that's their recommendation that goes to the Minister of Justice about what to do. I would imagine that they will be looking at the implications of the UK ruling when they, it's not too late. They'll obviously be a fair way through their paper, but this is it's a very significant piece of legislation for New Zealand. It's not something that they're going to just sort of, discard or ignore. So I think it's interesting that in the UK, it's shown that there is a way, when you clearly define sex, there is a way that you can provide anti-discrimination legislation for transgender people, if you can define transgender people. So that's something that they will hopefully pick up, that if you make a category, or you make a special characteristic or a protected characteristic for so-called transgender people, a really important part of that is then to define sex so that it can still stand alone, and where it needs to. And so hopefully they will learn something about that from this judgment, because the Equalities Act has is the characteristic, is it gender reassignment? Is that what it's called, Jo?
In England. Sorry, in the UK, yes, it's gender reassignment.
Gender reassignment. So we don't have that in New Zealand, but they're looking at adding something like that. So hopefully they'll learn and say we can add something a little bit like gender reassignment, but we have to be really careful that we define sex in the way that you've just done in the UK. So that's what I would hope.
Okay. Okay, so over the last week, Casey, I hope I've got her name right, Casey Costello, the Associate Minister of Health, gave instructions to New Zealand Health, that's our Ministry of Health, to use the word woman instead of person with a cervix or pregnant person. So she's saying we need clear language that people can understand. And this directive, just came out last week. So what is your response to her directive?
Oh, well, it's great. I mean, it's common sense. It's what's not to like, about something like that. It's good.
Yeah.
But it's ridiculous that we have to even go there, but it's,
Yes.
We'll take it as a win. Yeah.
Right. And do you think that might have any effect on, as both Casey Costello's directive and the Supreme Court judgment, do you think these might have any effect on what the Midwifery Council is doing with their scope of practice, where they've been trying to erase the word woman and mother, but they're running up against a lot of roadblocks, and they're once more now it's under consultation again, isn't it? Right now.
It is. Well, the midwifery scope of practice is a little bit odd in that the issue wasn't so much that they were removing the word woman and replacing it with person who is pregnant or whatever. It was that it's a uniquely New Zealand word, whānau, which means family. And the issue that we picked up, and lots of other groups picked up, was that you couldn't provide a medical service such as midwifery to a family. It's to a single person, and that person is the mother, and then later the child. So it wasn't so much about the traditional, I shouldn't say traditional, but the general issue we deal with which is trans inclusive language versus practical woman inclusive language. It was sort of a different thing. It was to do with not treating the woman as the central character in her pregnancy, and obviously it can't work. Health and Disabilities Act doesn't sort of allow you, a medical practitioner, to work in that way for privacy reasons. That the medical practitioner has a patient, and it doesn't necessarily include everyone who comes along with that patient. So that was more the issue with that one. But I guess it's all still sort of, it's relevant in that we need to look at what legislation focuses on women and whether it's doing it the way it should. Yeah.
Yeah. Okay. Now, also last week, I think it was, or this week, we had from New Zealand First, Winston Peters, the Deputy Prime Minister, announced that New Zealand First is going to put a private members' bill through Parliament, which is going to say that the words like woman and man have to have the biological meaning in legislation. I think it's called the Legislation Definitions of Woman and Man Amendment Bill, and also that this bill they're going to present will protect women's spaces. So what's your response to this announcement?
Well, it's a bit of a funny one, because the word woman is not really the contested word in our legislation. It's the word sex. So I think our Human Rights Act does contain the word woman in relation to one particular section, but it's not really the issue. So you could say that, you know, this is the meaning of the word man, this is the meaning of the word woman, but I'm not quite sure what the consequences of that will be. Like, it's not the word sex is the word they need to define, which is you know, so, but I guess it gives a bit of weight to the old legal or social contract that we used to have, you know, where everyone knows what a woman is. So I guess if you could say, well, woman is defined in law in this way. But in terms of saying that it's going to change it, or it's like a glossary of terms, isn't it? It's like, but it's like you're defining a term in the glossary that's not in the document. So it's kind of got limited use, I think, in legislation. But, you know, good on you, Winston.
Yeah, you're sort of saying that the words woman and man are actually not that much in legislation at the moment anyway.
No, they're not. I mean, there is, you're not in a way where, the word that matters is the word sex, because it features it. It's a character, it's a protected characteristic, but more than that, it's a characteristic that you are allowed to lawfully discriminate on the basis of. So that's where it's really important. Where man and woman, not so much.
Okay. So in March this year, Speak Up for Women presented a petition to Parliament, and the petition said that the House of Representatives defines that sex in the Human Rights Act 1993 and any other legislation has the biological meaning. So when I saw them doing these things, I thought, oh, that's sort of a bit like what you were asking for, but now you're saying it's not really what you were asking for exactly at all. The important word is
it's not. I think they kind of got an idea and sort of ran with it, possibly not quite in the right direction. But they accepted our petition, and our petition is going before the petitions committee, and we're actually working on a submission to go alongside it at the moment. And the UK ruling is going to form quite a significant part of that. And we did the petition because of the UK thing coming up. We knew, you know, that there were.
Oh, right.
So we sort of latched onto that. So we won't take any credit for originality with that one.
Cool. Good timing then.
Good timing.
So what about the relationships and sexuality education framework? Because that's been, you know, the relationships of sexuality and education guidelines have been very controversial now for a few years, because they included a lot of educating very young children about gender identity and really pushing those concepts. And how do you and the New Zealand First did get into the coalition agreement that they were going to they were actually going to get rid of that one and replace it with another one, and now they've got this one, which their framework that which they're looking for taking submissions on right now. So how do you see this new framework that they're proposing?
It's good. I mean, to be clear, it's actually not New Zealand First that developed it. It's national. Erica Stanford. So Erica, Erica and her team come up with it. No, what we've sort of pushed for in terms of sex education has very much been, don't throw the baby out with the bathwater. You know, there's lots and lots of very good relationships and sexuality education around consent, relationships, safe relationships, biology, you know, contraception, pregnancy, all of that sort of stuff. That, you know, in particular for women and girls, that's really vital that they're learning that. The more information they have about their bodies and relationships and all of that, better. But, you know, no gender identity, thanks. Let's not teach that people are born in the wrong body. So we're pretty happy with it. It's good. It doesn't talk about pornography at all that we can see, which I think is something that would be good to have in there. And we do wonder whether it would be worth them mentioning gender identity as a belief system that some people have, but not, you know, very clearly not taught as fact. Maybe for older kids, like sort of 14, 15-year-olds. that kind of age, just as opposed to just pretending that it's not a thing that features for some people, because there are people that believe it. But that would be very tricky. And I probably, if I had to just take what they've done now, the framework, I would. Yeah.
Cool. So just finally, if there's anything else that you think significant that might be happening in New Zealand because of the Supreme Court judgment, and do you think the tide is turning internationally, including here?
Yeah, I mean, the tide is turning. Yeah, for sure, I think. But we sort of speak up for women. We try to take a very measured, consistent approach. We're doing it through legislation, policy. The biggest issue in New Zealand is that our policies do not match our laws. So we have policies, for instance, our customs and police strip search guidelines. Now, they're based on legislation. The legislation talks about nothing but sex in terms of who can search who. The policies say gender identity. So, and they weren't done after 2021 when self-ID came in. They were done probably 2017. So, there's been this kind of push for all of that, and it's right through government. It's through all the NGOs that have anything to do with government. It's just everywhere. And so the issue we have is in comms. It's in getting the message across that that's not the law. Yeah, where people just think it is. So that's a massive job. But things like the UK ruling really helped with that, because there's so many people who just have no idea it's even happening, because the media are so quiet, and then things like this happen and they can't ignore it. So we get some airtime. So it's all good.
Great. Well, thanks very much, Suzanne. Well, we're out of time with that, so.
Yeah, and thank you for everyone.
Oh, thanks, Anna. Anna Kerr.
Sorry, you've done a great job. You've done a great job, both of you. Thank you. And now that completes the formal part of our presentation. And now we're going to move to the question and answer. And everyone should be offered, all our attendees should be offered the opportunity now to attend and ask questions.